3,982 people applied to got their permits. The sheriff's department just paid for it, and what happened in that courtroom changes how every gun owner in America should think about their Second Amendment rights. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from a decade in prison. Hit that button now. Here's what's coming. The exact lawsuit the Department of Justice just filed. The Supreme Court ruling that made the lawsuit possible. The reason 2 approvals out of 30. 982 is not just embarrassing, it's unconstitutional, and what every gun owner in America needs to do before they hand over their next permit application. Let's talk about why. This single number is the biggest gun rights story of the year. The headline number is real. Between January 2024 and March 2025, the Los Angeles County Sheriff's Department received 982 new applications for licenses to carry a concealed firearm. They approved 2. They denied 2. The rest sat in a backlog that, as of mid-2025, was still growing. That approval rate, literally 2 permits out of nearly 4,000, triggered the first affirmative gun rights lawsuit the United States Department of Justice has ever filed on behalf of applicants. Let me break this down for you. First thing, you have to understand what California's CCW system actually is. After the Supreme Court decided NYSRPA v. Bruen in June 2022, California was forced to rewrite its concealed carry laws. The legislature passed Senate Bill 2, creating what is technically a shall-issue framework. That means a sheriff is supposed to issue a license if the applicant meets the statutory criteria. The applicant has to be 21. The applicant has to complete a training course. The applicant has to pass a background check. If those things check out, the license is supposed to issue. Second thing, the shall-issue label is technically true. The practical reality for 3,982 Los Angeles County residents was something else entirely. They paid the fee, they sat through the class, they submitted fingerprints, they waited, and they waited, and they waited. Third thing, some of those applications had not received a final decision more than a year after submission. The Dodge complaint called this a pattern and practice of delay that functioned as a de facto denial. And there is the legal point, whether the sheriff technically calls it a denial or simply never gets around to ruling, the effect on the applicant is the same. No permit. No legal concealed carry, no Second Amendment exercise. That's why the case got the Department of Justice's attention. Now here is the part nobody is talking about. The Dodge could have brought this case under any one of several civil rights statutes. They brought it under the Second Amendment directly, using a theory called delays that operate as denials. The argument went like this. The Constitution protects a right. The state has set up a process to license that right. The licensing authority is supposed to act on applications within a reasonable time. When the licensing authority simply refuses to act, the right is functionally extinguished, even if no paper denial has been issued. That is a very big deal, because until now, most CCW fights were about whether a discretionary, may-issue scheme was constitutional. Bruen answered that question. Yes, may-issue schemes are unconstitutional. Now the Dodge is taking the next logical step. Even if a scheme is officially shall issue, if officials simply ignore applications, the scheme has the same unconstitutional effect. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Here's what you need to understand about why this number matters so much. The approval rate is not just a bad policy outcome. It is the kind of evidence that courts love. Judges like math. They like percentages. They like clean comparisons. When the Dodge can walk into a courtroom and say, Your Honor, the sheriff has approved 0.05% of applications in this period, the judge has a story. Before anyone even argues the law, the math itself tells the story. Now look at how this compares to other California counties. Population-dense Contra Costa County approved the vast majority of its applications inside the statutory window. Kern County, more rural and politically conservative, processes applications quickly. Even San Francisco, which historically had one of the toughest may-issue systems in the state, moved to a more functional process after Bruen and somebody too. Los Angeles County, the largest sheriff's department in America, set the worst record of any major California county by an enormous margin. That comparison matters for one specific reason. It shows the bottleneck is not the law. The bottleneck is administration. When other counties with the same statute, the same training requirements, the same eligibility criteria are processing applications normally, you cannot blame somebody too for a backlog. You have to blame the sheriff. Now turn this around and look at it from the gun owner's perspective. This is where I want you to imagine yourself, not a hypothetical, but a reasonable, law-abiding person trying to do the legal thing. You live in Los Angeles. You are not a felon. You are not subject to a restraining order. You You have no history of mental health adjudication. You have never been convicted of a misdemeanor involving violence. You are exactly the kind of person the Second Amendment protects. You decide you want a CCW permit. The reason does not matter. Maybe you have had recent break-ins in your neighborhood. Maybe you travel into rougher areas of the state. Maybe you simply want the option. Step 1. You read the California Attorney General's website. You follow the instructions precisely. You complete the 16-hour training course. You pay the fee. You submit fingerprints. You wait. Step 2. After 90 days, nothing. You call. You are told your application is in process. After 180 days, nothing. You call again. You are told the same thing. After a year, you receive a letter stating you need to submit additional documentation. That documentation is the same documentation you already submitted. After 14 months, you have not received a final decision. Step 3. You hire a lawyer. The lawyer writes a careful letter citing the statutory deadline and the constitutional principle. The sheriff does not respond. You learn that 3981 other applicants are in the exact same boat. Here's the part that would have been unbelievable 10 years ago. In 2026, the United States Department of Justice itself has now intervened on the side of those applicants. But wait, there is something even more important that almost nobody is covering. The settlement that ended the lawsuit, signed off by the same sheriff's department, contains structural commitments. The department agreed to specific processing timelines. It agreed to a presumption of issuance once statutory criteria are met. It agreed to public reporting of backlog numbers, and it agreed to ongoing federal monitoring. That is significant because the sheriff did not just lose. The sheriff redesigned the system under federal supervision. That has not happened on a CCW question before. Now let's pull the camera back. What does this mean for you if you do not live in Los Angeles? Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. It means 3 things. First thing, delay refusals are no longer safe if you're local. Sheriff runs a CCW system that simply does not process applications in a reasonable time. You now have a federal roadmap. The Doge's theory of delay equals denial is now settled. Law in this circuit. Any similar pattern elsewhere invites similar litigation. Plaintiffs' firms are already watching this. Second thing, the Second Amendment is a usable right now, not just a paper. Right? Before Bruen, only a handful of states respected concealed carry as an ordinary exercise. After Bruen, all may-issue schemes were declared unconstitutional. After this Dodge lawsuit, even functionally slow. Shall-issue schemes now face direct federal exposure, that is 3 years of compounding pressure on government officials to actually honor the right. Third thing, the training and eligibility bar is not going away. California's process includes an extensive training requirement. The settlement did not weaken that. A shall-issue framework still requires the applicant to meet all statutory conditions before issuance. None of this opens the door to casual permit issuance. It just opens the door to timely permit issuance. So if you are a California resident planning to apply, here is the practical takeaway. Your application is now part of a federally monitored system. You have statutory rights that you did not have 3 years ago. You have a presumption of issuance. If you meet the objective criteria, and if you don't receive a real decision in a reasonable period, you now have standing to sue, and you have the Doge's own lawsuit as your roadmap. Now let me make this even more personal for you, because that is the part most legal commentary misses. This is what actually changed in your daily life. Before this Dodge lawsuit, an applicant whose application sat in limbo had very limited practical options. They could write the sheriff, they could call a lawyer, they could file a state court action under a mandamus theory, asking a judge to compel the sheriff to act. But those tools were slow, expensive, and frequently unsuccessful. Against a politically entrenched sheriff, after this Dodge lawsuit and the resulting settlement, the applicant has at least 3 new doors. Door 1. A federal complaint already provides a public template. Plaintiffs' lawyers across the country are reading it line by line. Their bar associations are filing similar actions in other counties. They will file under both the Second Amendment and various state law analogs. The Dodge has effectively built the complaint for them. Door 2. The monitoring provisions in the settlement create a paper trail. If your local sheriff has to publicly report backlog numbers, that report becomes evidence in your next case. If the sheriff slips back into delay, the publishing of that delay becomes the basis for a follow-up lawsuit. Door 3. The political pressure is now national, congressional. Committees are paying attention. State legislatures are paying attention. Civil rights groups are paying attention. A sheriff who runs a near-zero approval rate is no longer just an embarrassment in a local newspaper. They are a federal defendant. Let me show you where this all goes next, where it lands in the rest of 2020. 6. This information could literally expire after January 2027. Subscribe now because the next video explains exactly what you need to do before that deadline hits. The Supreme Court is likely to take up at least one more Second Amendment case in the coming term. The pipeline of CCW cases from California, New York, New Jersey, and Maryland is enormous. The DOJ's affirmative gun rights lawsuit just added fuel to that pipeline. It is now routine for federal courts to consider not just whether a permit scheme is constitutional, but whether the administration of the scheme is constitutional. Expect more cases. Expect more settlements. Expect more sheriffs to voluntarily restructure their processes before they get sued. For you, the practical takeaway is simple. Don't let your rights sit in a backlog. If you apply, document every contact, keep every email, save every receipt, note the dates. If your application stalls, escalate quickly through a lawyer before a federal pattern and practice case becomes the only realistic path. And if you live in a state where CCW is genuinely shall issue and processes applications in a reasonable time, that's the system to learn from. That's the system that complies with both the letter and the spirit of what Bruen and the DOJ now expect. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. State CCW laws differ dramatically. California's statutory framework is not the same as Florida's, Texas's, or New York's. Your eligibility, your training, your fingerprinting, your renewal cycle, and your protected places all depend on the state you live in. Use this video as a map of how the law is moving. Then talk to a lawyer licensed in your state before you file. 3,982 applicants, 2 approvals, 1 sheriff, 1 lawsuit that just changed how every county in America will administer concealed carry permits. That is the story, and that is why you need to understand it. The Second Amendment is no longer a paper right that sits in a binder somewhere. It is now an operational right that government agencies are being compelled to actually honor. That's the lesson, if you are a law-abiding adult. Your local officials now have a positive obligation to process your application, give you a real answer, and do it on a reasonable timetable. If they don't, the federal government just showed exactly what happens when they fail. Hit subscribe so you catch that next video on the 5 words that protect you in a CCW encounter. Smash that like button if this just changed how you think about your permit, and drop a comment telling me what state you are in, because the playbook looks different in every one of them.